Lordship's kind permission. But yesterday I mentioned I'll give a chart. I just prepared it for your Lordship's convenience. Severable, non-severable. And maybe after the others finish, I can just explain it.
Yes, please.
Yes. I made severable, non-severable, then within subparts. But I'll explain it after the others finish.
Something all part of your argument.
Pardon me?
All part of your
No,
argument.
I just want a chart so easy to follow, but not so that's why.
I catch up.
No, the only thing is, in 34.4, we have not addressed the meaning of the word appropriate. I don't want to interrupt others because when I come, the 34.4 as a word appropriate, it's not necessary, it has to be sent back. The court may find it inappropriate, the court may decide itself. That point I'll clarify later.
Yes, please.
Please, my lords. I want to repeat what has already been argued previously. Just run through it quickly. I think your lordships have already heard enough of us. We have an opportunity right now to really set right a problem which we've been plaguing us for the last 20 years. Litigants being run between court to tribunal and vice versa. Or do we dig ourselves our heels inside and say, sorry, there's nothing that we can do. This is how the system is. We submit it's the former. That is an imaginary problem. Section 5 is not really a valid answer to the problem. Section 5 is actually a gateway, not an obstacle. Section 5 permits a Section 34 court to intervene in any manner it wishes to once the gateway is open. Because Section 5, the last part of Section 5 reads that the court may intervene where so provided. It doesn't say in the manner so provided. The reading of Section 5 is only a gateway to get inside, and once that opportunity is there, whatever powers the court wishes to apply are available to it. It appears at the end of Section 5, my lord. The second is, to what extent should there be corrections permitted to an arbitration award? And we submit, and this is a very important aspect, because if your lordships hold it, it should not be done too widely, because we'll have another problem being opened. We submit it should be restricted to certain aspects only. Number one is when there is a non-discretionary aspect, that is either there is a statutory right or a contractual right. 1. 2 is if it is a matter of modification of an interest. And 3, if there's any calculation related errors. Now, it is why this is so important is because it leads to the entire concept of enforcement of rights, what a statute provides. If the tribunal is not either rightly or wrongly ordering that, awarding that, if a court does not correct that, it puts a big question mark on ease of enforcement of contracts, on the rule of law that we're enjoying. Because then the moment you see litigation dragging on, somebody going from court to tribunal, it casts a question on our ease of doing business in India, which is why there must be certainty, finality, and efficiency in the entire process. Therefore, these are from a policy perspective. I think the legal points have already been very adequately covered by my learned seniors. Now, we've tendered a note. In that note, my lord, we've already dealt with the series of judgments which already my learned colleagues have dealt with as to where the court has previously interfered with awards. The only relevant one I want to show, my lord, is the Hindustan Zinc versus French coal carbonization. In that, the Section 34 judge modified an award. A Section 37 judge, as a 2006 for SEC, the Section 37 judge set aside the Section 34 order on the basis that it should not have been modified with. The Supreme Court said
Page number.
for 2006 for SEC 445.
2006.
2006 for SEC 445. Hindustan Zinc versus French coal carbonization, where the Supreme Court upheld the Section 34 order allowing the modification. And that is the correct system we submit that must be followed.
But what was the modification made? What was the modification made?
That was on the main merits of the matter it had gone on to, on the calculation of the damages.
Computation of damages. Where is the reasoning given? But without reason, they just applied.
Para 25, 24 onwards. The basis of the calculations.
It is on the basis of calculation.
Last line, the order of the division bench is unsustainable as it fails to interfere with a portion of the award which is opposed to the specific terms of the contract on the other hand, the trial court had correctly decided the matter. So in that category of if it is a contractual right, statutory right, interference must be there. If it is calculation of an error,
Statutory
interference
right, then you're rewriting the award.
only to this limited extent where there is no discretion.
That, no. When,
Yes,
say
but
in a contract says, no escalation, come what may,
then there is no discretion.
even if we extend the time, arbitrators normally find a way to get over these clauses.
Correct.
Because in equity, these clauses are one-sided, completely one-sided. There's a direct form contract.
So if the court feels that
If we do that, then virtually we'll be rewriting the award.
so just to correct, rewriting the award to a limited extent is not a bad thing. Rewriting the award because if one follows a policy that no rewriting is the policy which is being advised by the other side and is the one that is causing the problem. So partial rewriting in these limited circumstances should be permitted for a systemic benefit is what our submission is. So if there is a discretion to the tribunal, then court should not interfere. But if there's no discretion, if there's a contractual right, statutory right, then the court must interfere in those cases. We have to lay down limits.
Will setting aside include that part?
So that point has already been adequately addressed. So setting aside includes a limited right of modification and modification not quite, but with this limited aspect, my lord. Main point is the huge expense, effort that parties have undertaken.
Okay,
We
fine.
nipped into
That's
the
all.
bud. Just 2-3 more points, my lord. There's another risk of this section 34(4) I'll just address. Is this if a court refers it back to the tribunal and tribunal maintains its view, this is a risk of an infinite bounce. It will come back in a 34 may again hold its view. It's again a never ending process, litigant suffering right throughout. Again on 34(4).
So already argued so many times.
I'll just make 2 more points, my lord. 34(4), 90% of the entire work is already been completed. Why not just finish it instead of sending them back all the way to this? And at many times, the lordship should have seen tribunal is no more available either because of age or retirement. So a lot of practical difficulties are there in referring matters back to tribunal. So it is best from a commercial as well as practical and legal that the matter be closed at that stage. So we've seen international statutes. They provide for the power to modify. We've seen US, Singapore, Australia, England. The only one that prohibits is in Singapore in the context of international arbitration. In our case, we have a clean slate. So we have the opportunity to set right what we think is correct. And that is what we submit should be done. The statutes are already provided by Mr. Mehta in his written note. I'm grateful to my lords.
Please call out the name.
Please, Lords, while adopting the submissions of my erudite senior colleagues, Lords, on the reason why Lordship should in fact permit modification of awards, I want to focus on a very limited aspect. Lordship's repeated query during the course of this hearing has been, if we agree that this power is there, what is the Lakshman Rekha that we will draw for identifying the scenarios and the benchmark when this power should be exercised? So, my lord, I am only arguing on that issue because of the limited time available with me. Lordships may kindly have my written submissions, paragraph 4, where I have sought to encapsulate 3 scenarios where the Honorable Court may consider exercise of this limited power of modification. If Lordships would be so kind, my lord, to have my written submissions, if all the Honorable Judges have it, my lords, may I just place that?
Yes.
Because I am just requesting my lords to have with me paragraph 4 of my written submissions. I've also handed over extra copies, so any honorable member of the bench, deeply obliged. Because may I place paragraph 4, just the initial portion. Various scenarios would arise where the interest of justice, as also institutional effectiveness of arbitration as a form of alternative dispute resolution, would be better subserved if courts can modify an award without relegating the parties to a second round of arbitration, provided that such a modification would not require a detailed inquiry into the facts of the case. Now, please see 3 scenarios, my lords. For instance, in one scenario, scenario 1, an arbitral tribunal may deny interest on the claims in toto. However, if the court determines in a section 34 or 37 proceeding that interest was unjustly denied, the court should have the power to modify the award and grant a reasonable rate of interest without relegating the parties to a fresh round of arbitration on this sole aspect. In another scenario, scenario 2, if the court determines that the interest granted by the tribunal is unsustainably high or low, the court should have the power to reduce or increase the interest rate without having to remand the parties to a fresh arbitration with regard to rate of interest. Now, these two, my lords, are relatively low-hanging fruit. Now, please see the more controversial scenario 3. There might arise a third scenario, scenario 3, where the findings of the arbitral tribunal might be ex facie contrary to the record of the tribunal or the agreement between the parties, and modifying the award would not require an elaborate inquiry into the materials already placed before the arbitrator. Now, my lord, for this third scenario, I wish to place before my lord a judgment of the division bench of the Honorable Delhi High Court, which would show to my lord exactly why this limited curated power should be available. My lord, please have my judgment compilation. There are many judgments there. I'm only going to show lordships 2 of them because of the limited time that I have at my disposal. Please see this judgment, which is at serial number 1, page 1, IRB Infra. My lord, this is a new judgment compilation that's been handed over. I have removed my earlier one because most of it was already covered. This is, my lord, running into 79 pages. I hope lordships has this judgment compilation.
Yes.
Yes, lordships may just see the first judgment of the division bench in IRB Ahmedabad versus NHAI. My lord, the facts were interesting. The contractor in this case files a claim, which lordships will find at paragraph 4 at page 2, seeking an award that it is entitled to issue passes without offering discounts to local commuters on the highway. So the majority award finds that yes, you are entitled, you don't need to give a discount to the local commuters. Now the NHAI filed a counterclaim, which I'll take lordships to, which said no, direct them that they must provide the discount. Now in the section 34, the single judge sets aside the award. The contractor appeals to the division bench. The division bench upholds the single judge's order, but now please see what the honorable division bench does. So lordships will now note this interesting formulation. Please have with me, my lords, paragraph 36 at page 15. This is a perfect example of scenario 3. Please see para 36 minutes at page 15. May I read, my lords?
Yes.
Before the arbitrator, the NHAI had filed counterclaims and prayed as under. In view of submissions made above, the claims of the claimant may be rejected and the claimant be directed to. Now, please note, my lords, Roman serial 1 and 2 are precisely the counter to the claim, which is direct them to issue discounted passes. Now, my lord, please see para 37. That's pregnant with legal consequence. The arbitrators in the award did not go into the counterclaims of NHAI, but granted the claims of appellant. Since the stand of the appellant has been rejected and award has been set aside, it is directed that the NHAI shall ensure that the concessional passes, discounts and exemptions as per notified toll rates are being extended to commuters and users. The appellant shall submit all its accounts within 8 weeks, who shall be entitled to recover all the excess amounts charged by the appellant. Now, my lord, the unarticulated premise of what the Honorable Division Bench says is, it's a useless formality now to send the NHAI back to a fresh arbitration to again agitate its counterclaims, because the courts applied its mind and the courts found that the stand of the contractor is completely unsustainable. Now, in a situation like this, my lords, will the courts now relegate the parties back to a fresh arbitration for something that's ex facie clear? Now, my lord, one question which will come is, all right, this is one factual scenario. How do we lay down a test? Now, my lord, with my limited understanding, my respectful submission is, and I say it with all responsibility at my command, useless formality. Useless formality is a controversial doctrine in administrative law. Because lordships knows in administrative law, there is this dichotomy between the principles of natural justice not being applied and admitted facts leading to a particular conclusion. So that's a controversial doctrine in administrative law and service law. But please see, my lord, if we remove that element of natural justice, which would not arise here, please see one formulation which I can commend for lordship's kind acceptance. Please see page 56 of my judgment compilation, which is, my lords, part of the judgment of this honorable court in MC Mehta, which begins at page 49. Please have, my lords, page 56. Please have with me para 21. Now, this is in the context of useless formality in administrative/service law, but please see para 21. Now, lordships may ignore the first words beginning with, it is therefore clear that. Please start with, if on the admitted. Please note this, my lords. Lordships has that, my lords. At para 21 at page 56, my lords.
Yes.
At 21, please ignore the initial words. It is therefore clear that now, my lord, please mark from here, if lordship would be so kind. If on the admitted or indisputable factual position, only one conclusion is possible and permissible, full stop. In my respectful submission, for determining scenario 3, this strict test lordships would consider employing, because in my respectful submission, and I will just end with that, arbitration is a chameleon. Lordship saw the judgment in IRB. Even though arbitrations are ultimately private contracts, in many ways, they overlap and interface with issues that affect the larger legal system. And my lord, these are not my words. Please therefore permit me to conclude with just one more reference. Lordships may have, my lords, in my judgment compilation, the article, my lords, at page 59. Now, this is, my lords, a 1952 article, which is considered the most unadulterated normative exposition of arbitration because of the genre and the era in which it arose, relatively uninfluenced by the commercial explosion that's happened thereafter. Now, my lord, this article, my lord, lordships may kindly see at page 59. And my lord, I will just take lordships to page 63. We think arbitration, we fetishize arbitration today as purely being this commercial agreement between two parties. But arbitration goes beyond that. Why does it do so? Please see page 63.
Yes.
Lordships may note the 5 components of arbitration. I will trouble my lords with A, B, and E. Please let me start with A. Arbitration as a creature of the parties. My lords has that, my lords, at 63. May I read?
Yes, please.
Yes. The statement that arbitration is a creature of the parties, that its occurrence, form, and scope are dependent on the will and consent of parties, is but part of the truth. Although the arbitration agreement, as any agreement, is consensual within its limited compass, it is also in varying degree depending on the law of the particular jurisdiction. Now, please note, my lord, a delegation of the power of the state to private parties for their private ends. That delegation proceeds on the assumption that the attainment of those ends will also subserve public interest with a sufficiently high degree or incidence to justify such delegation. The basic assumption is, as we pointed out in the preceding section, that arbitration is an allowable extension of the sphere of contract, yet the fact that it is consensual profoundly affects the nature of the award and the value sought to be served by the award, and hence the determination at the ends of the attainment of which the power of the state will be brought to bear. Now please see B, arbitration as an award. The fact that the arbitration process involves a delegation of the power of the state also must be considered in the evaluation of the process, for the exertion of this power will channel conduct within or between institutions as the case may be, and thus have consequences with which society must be concerned. Now, my lord, please see C, arbitration as a settlement of a dispute. This is what we primarily focus on, to the exclusion of the other elements. Now, please see D, arbitration as a procedure before a tribunal. This also we focus on. Now, please see E, my lord. This is critical, which is why the court's exercise under 34 and 37 must be cognizant of this complexity. Please see E, my lord. Diverse nature of the arbitration process. It will be evident from the foregoing that one of the fundamental propositions of this article, that it is erroneous to assume that the arbitration process remains the same and is uniform wherever the elements of its structure appear. It is erroneous to assume that arbitration is purely a structural concept definable by the occurrence of the elements noted in the definition at the outset of this article. An individual may be identifiable by the presence of a typical sentient anatomical structure. The personality of an individual, however, emerges when he is viewed in a social context. Similarly, the nature of an arbitration becomes revealed when it is viewed in its social context. For arbitration is a chameleon word, assuming varying significance as the social setting in which it takes place. Now, my lord, after this normative exposition, jurisprudential in nature, please see its application to commercial arbitration. That is what today we mostly engage with. Please have with me page 77. I'll conclude with this. Please bear this in mind, my lords. Please see page 77. Please see Roman 10, nature and role of commercial arbitration. I'll just read this one para and conclude.
Yes.
Yes, may I read? The term commercial arbitration implies the arbitration of disputes arising in the life of trade and commerce. A dispute involves a deviational transaction in which an established customary expected course of conduct fails to be carried out as anticipated. The particular parties to the dispute may or may not have been involved before in similar transactions. At least one of the parties, however, will have performed many similar transactions in the past, so that its behavior will have become institutionalized, and there will thus be a pattern of practice or norm against which the deviational transaction can be appraised. The fact that this pattern of practice, which usually involve an external relation of a business institution, is of little social significance. The significant circumstances to be examined and weighed in determining whether a deviational transaction should be approved or condemned are: first, the nature of the established norm of conduct against which transaction to be measured; second, the nature of any general rules of law relevant to such transaction; and third, the nature of any special rules of law established by the party to govern the transaction. Now, my lord, the next two sentences are pregnant with consequence. Thus, no dispute can be said to be isolated or discrete. The parties may be, but not the institutional relationship in the performance of which the dispute eventuates. So we saw a practical example of this, my lords, in IRB infra, and this is why our courts, particularly our constitutional courts, my lords, must retain that limited scenario 3 power. And I am not, my lords, at all postulating that in 34 or 37 there should be a knight errant, a judge should be a knight errant, or impose subjective conceptions of justice or equity. No. But if the facts are undisputable, if they are clear, then lordships must permit, my lords, modification in scenario 3 also. Because that's my respectful submission. I'm so deeply obliged. Because my notes don't capture this because they were on a wider campus. I'll just, my lords, put in a revised note, just focusing on this.
Yes,
I'm
please.
so deeply.
Next.
I'm only giving a short note, Your Honor. I'm only on the objective of the Arbitration Act, Your Honor. May kindly have some of the objectives of the Act, Your Honor. They are providing speedy disposal of the disputes, providing for amicable, swift and cost-efficient settlement of a dispute. I'm taking just an illustration, Your Honor. In my case, I'm just taking the dates. In 2002, an arbitrator was appointed. 2010, the arbitration award was passed. In a cross appeal, one of the claim was allowed. In 2010, the Section 34 was filed. 2019, Your Honor, the Section 34 was modified by the High Court, single judge. 2024, Your Honor, the division bench set aside on the basis of Mohammed Hakim judgment, Your Honor. 22 years, Your Honor, has taken place. Your Honor, asking us to go back in a case will be against the very objective of the arbitration. Your Honor, let's take an example in a cost sufficient, Your Honor. In a civil suit for 10 crores in Delhi, the court fees will be around 10 lakhs rupees. Whereas it's arbitration, if there are 3 arbitrators, the cost will be around 37 lakhs 50,000 plus the other expenses, Your Honor. Asking us to go back after 20 years or 10 years, I will say, and give the same court fees again will be the very against the objectives of the Arbitration Act itself. Because it has to be cost efficient. The objective is it should be cost efficient also. Now let's take an example again. Let's say in a 10 crore civil suit or 10 crore dispute, Your Honor, the modification is about rupees 50 lakhs rupees only. Arbitrator has passed an award and the dispute is only about difference of 50 lakhs. Now that arbitrator, if we will ask him to set aside that arbitration award, then this amount of 50 lakhs rupees will go only towards the cost of the arbitration itself. So the objective is to see the finality of the judgment should be there, where the arbitrator should feel that, where the court should feel that sending the matter back will itself defeat the very purpose of modification itself. The court should allow in that way, in those matters. Okay, please. That's all.
Was IFPN IF 40905. And a summary of my submission is that the power to modify comes from 34(4). And it should be done only in the manner which is prescribed by the statute. 34(4) does not entail that the court should take cognizance of the matter, because the moment it takes, then doctrine of merger starts applying, which is not anticipated by 34. It's a hands-off approach situation, but the honorable court will always have the power to tell the arbitrator to modify the award. That's my humble submission. Now, because it is also important to note at what stage and why should 34(4) be resorted to in the first instance. Of course, Milos, the learned seniors have already submitted why we should first try to save the award. And that principle actually comes from the pro-enforcement bias that is there in 34 Milos. There's a judgment of Vijay Karya, which is under section 48 of this act, where my lords have held, looking at the language, usage of the word may in section 48. And they say that, look, first endeavor should be to enforce the award, even when we agree that certain grounds for objections are made out. Because the word uses may. The same expression is borrowed in section 34 also. Section 34 also says an arbitral award may be set aside by the court. So therefore, the first endeavor has to be to save the award. The additional reasons why I'm making this submission is also the principle of minimal curial intervention. And second would be doctrine of proportionality means. Now, it may be debatable what is more minimum curial intervention. Is it simplicity setting aside or keeping the matter with itself under 34(4)? My humble submission is that not setting aside the award or not using the draconian provision of setting aside the award actually confers with the minimum curial intervention principle under section 5 of the Arbitration and Conciliation Act. And this is also in conformity with the doctrine of proportionality as well, where for minor errors or small errors or curable defects which can be corrected, resort to 34(4) must be made before 34(2) Milods. Now, Milods, one thing that comes in the way is the sheer language of section 34(4). Now, it has been submitted at the bar, Milods, yesterday, and there's a judgment also against me. Kesari Malik Milos, 3 judges. And I just read the provision. On receipt of an application under subsection 1, the court may, where it is appropriate, and it is so requested by a party. So this expression, I think it fell from Justice Kumar also yesterday, that it is so requested by a party, Milods. This has been interpreted by Milods to say there should be a written application. In my humble submission, Milods, that may not be the correct position. Because number one, if they wanted to say application, they would have used the word application because they've used the word application at least 10 places in the statute. So they deliberately avoided the word application. Number two, Milos, in my humble submission, this is not a precondition for using the power. This is more of an ex post facto seeking consent/compliance. Now, the reason for such a submission is that since the court is duty bound to save the award, therefore, party taking that initiative should not be that condition. Number two, the language itself says, first the court will see where it is appropriate and it is so requested by a party. So I'm not saying that this and should be or, but I'm just saying a proper interpretation of it is so requested by a party should mean ex post facto consent. Now, why such a provision is there? Of course, my lords, learned SG took my lords to the preparatory articles, and those discussions, etc., do not dwell upon why there should be this power of seeking a request or consent of the parties. But my lords, my submission is that it should not be a futile exercise under 34(4) to remand the matter back. For example, there is a situation where mitigation of damages is not considered by the arbitrator. And the award could, of course, go because it will lead to unjust enrichment. So a party would have to consider that is it worthwhile for me to spend money and go back to the tribunal? And at least one party should find sense in that procedure. So only to ensure that it is not an exercise in futility, at least one of the parties must benefit out of that process, and therefore at least one of the parties should give consent to it. If the basis for such was party autonomy, then both parties should have consented, or the provision would have provided for both parties. But it only says only one party needs to benefit out of it. So therefore, only one party needs to request.
But what will be the scope for the 34(4) proceeding?
My
That
lords.
has to be formulated in an application. You are saying court will formulate it
My
in an
lords.
order and take the
My lords, I bow down to that, my lords.
Possible in all scenarios.
Correct. So if I were just to go for the literal interpretation on what the tribunal can do once that order, once 34.4 is in cognizance of the court, there's two level test. One is the means test, other is the ends test. The ends test says that the arbitral tribunal will enumerate the grounds. So the 34 court can lay down the grounds that, look, if you don't change your order, I will set it aside on these grounds. So you are hereby given an opportunity to cure these defects, if at all they are curable. And the means test is, what all can the tribunal do to eliminate these grounds? Take such other action as in the opinion of arbitral tribunal. So tribunal is at liberty. Now, this is not a remand under order 41 rule 23, 23A, 27, where the appellate court itself says that, look, you're supposed to do these things and the consent of parties is not required. Here, the tribunal is at liberty. Tribunal has the opportunity to eliminate the grounds for setting aside the order. This is the interpretation. However, my lord, there are instances of Singapore judgments, which are also referred to in learned SG's submissions, where the courts have had put an annexure A to the order, and they have said, look, these are the 4 issues you need to determine now to cure the defects. And the matter has gone back to the tribunal to look into these 4 issues. Of course, there were subsequent disputes of what this order means and what the tribunal can do. But this is one way, my lords, I saw that the courts were exercising this power under 34.4. And contrary to Kesari Malik, my lords, we simply say there should be a written application, because my submission is it can be just a consent of the parties. And there are 2 judgments. One is of Madras High Court, one Calcutta High Court. I have referred to in my submissions. I'll just point out the parameters, I will not read it, which simply says it's a procedural requirement. My lords may have page 5. Page 4 bottom. It's a thin submission. Well, I'll hand it over. I have extra. I'm sorry, because one is not in the form of paper. Fine.
Yes, please. No, you're referring to this one.
My name is Pallav Mongia, my lords, should be filed in my name.
Yes, that's there.
That's the one. That's the one. Page 4 bottom is just a 7-8 pages submission. My lords.
Yes.
Page 4 bottom.
Yes, where we can refer to MMTC.
MMTC, my lords, absolutely, my lords. And honestly, I won't read the paras, but my lords, though these judgments say they are procedural in nature, but my submission is it should be mandatory, but in form of a consent, not in form of a pre-application. It's not a trigger point. It's more of a case of ex post facto compliance. Because if the, because my lords, once the court has made up its mind.
You can understand if you say that oral application, written application may not be necessary.
My lords.
But on an oral request, it will be made.
My lords.
Then how can it be post facto?
No, ex post facto in the sense that first the courts made up their mind and then they seek consent, not that after the tribunal exercise. My apologies. I'm sorry.
Consent of whom?
Consent of one of the parties. Because it should not be an exercise in futility for the parties.
I think we're going in absolutely. Look, it's for the court to decide. Courts know how to deal with it. When objections are there, normally what happens? The party which is objecting, it can be 2 situations.
Right.
The party which is objecting to the award may come forward and say, please get it corrected. But the greater possibility is normally the party which is defending the award.
Correct.
And
Correct.
gets confronted with a situation where they are not able to defend the award.
Correct.
They may ask them to be sent over there.
So that winning party will make a choice that, for example, mitigation of damages ground is not there.
The party which wants the award to be, defending defending the award. Like in a given case, it can be the other party.
Exactly, Milo. That's my point.
But normally a person which is defending the award, they find it's impossible to defend it. So they say, please send it.
Exactly. So
But
it
then
may say that, look, mitigation of damages considered.
we should not now go into say, how should application should be moved, whether it should be.
No, that's exactly my point, my lords. If my lords were to say that this is not a
No,
application
the only
mechanism.
question is whether any modification can be done.
Correct.
Correct.
If it
So
can be done to what extent?
correct, my lords. Correct. So this is a process which will trigger that
We
power.
are not going to- process is very, the language is very clear, where it is appropriate and it is requested.
It is so requested. It is not an application.
So even if a party makes a request, the court finds that it is not appropriate,
Correct.
court may still reject it.
Correct. Now, I just point out two page numbers. I won't even take my loss to that. There are two Singapore judgments which are referred by the learned solicitor in his written submissions. And in the compilation 4, at page 1772, there are instances where the courts themselves said that you please address me on 34.4. The court invited submissions and it's recorded as part of the transcript, not just a recording in the law reports. my lords.
Yes.
What is the name of the Singapore case?
I'm sorry. My lords, one is Bagadia Brothers.
That's Indian case.
No, my lords, that's Singapore, my lords. Bagadia Brothers versus Ghanshyam at page 1772.
Volume 4. Yes.
In the first para itself, fourth line, my lords. On 12th April 2022. I'm sorry, Justice Vishwanathan.
Right, yes. Yeah, what was the page? 1770. Yes.
My lords, fourth line from the top, para 24. My lords have it, my lords. On 12th April 2022, I further directed the parties to address me on the applicability of 34.4 of the model law to the present application and whether it would be appropriate in the present case to remit the award to the arbitrator. There was no application. my lords. In fact, an objection was subsequently
Why are you
taken.
going into all this?
I'm going for all this. my
Courts
lords,
know how to deal with this issue.
No, Milos, because it has been, Milos, in my humble submission, the requirement that it should be a written application, that may not be
Just
required.
keep that part.
And if it is so interpreted in such manner, then the power of modification indirectly comes.
We did not go into that question.
I bought a Milos. I just bound to share this. Then Milos may have just one more page. On the next page, it's a chart. I'll just show that chart and I'll just end with it, Milos. Page number 8, there's a chart in my written submissions. Milos may have the chart. Just, I'm so sorry. I'll trouble you. Just 30 seconds.
So we have understood the chart. It says where there's uncurable defects, it has to be set aside. Where the
First-
curable defects.
Correct, Milos. There must
that's
be
the court will
under
try and
34.
solve it. If the court cannot solve it, then it cannot, can be sent under 34.4.
Correct, Milos. And Milos, Indian Milos, there's just one more.
Done by Mr. Datar.
Almost.
Milos, this aspect was not argued.
be used, it has to be sent back to the arbitral tribunal.
My lords,
Be
in
modified.
priority, it should be used first, try and save.
By the 34 court itself, but it should be sent back to the arbitral tribunal.
No, yes, my lords, it should be sent back to the tribunal. The court itself cannot do it, my lords. That's my humble submission. And with regard to one question that fell from Justice Vishwanathan yesterday regarding whether quantum can change or not, my lords, there's one judgment of BRS versus BRQ. It's at page 1429, again a Singapore judgment, where the court itself noted that the quantum will change, but since it has to be sent back for the reasons aforesaid, all 34(2) grounds, therefore let that be the consequences. Because in my humble submission, my lords, this is not an opportunity for the parties to improve their case, but for an opportunity to the arbitrator to do a better job and ensure that the grounds are eliminated.
To remove the defects.
To remove the curable defects. Because of course, certain things can't be moved. And conclusion is on page 9. And there's a summary of my submissions also on page 1. I'll end it. I'm obliged. Okay.
But
No, you are the other
they
side.
cannot be modified because of the IA was like this. That's why
No, no,
I can be taken up. Milord.
Any other names?
Our bare bone proposition is that when your lordships are to locate the power to modify or vary, whether it is to be located as part of the power to set aside an award, which is a larger power, my lord, or is it a standalone power which stands in its own right, my lord? My lord, my submission is that as much as the power to set aside is a power, the power to modify is a power in its own right, my lord. But why I would say this is, I've handed over just 5 sentences note, my lord. My lord, although the words used under section 34 is only the power to set aside, my lord. My lord, but there is certainly the power to refuse to set aside the award, my lord, which is to confirm the award. There is also, my lord, the power that if the parties agree, then the court can pass an order in terms of the agreement of parties, my lord. My lord, all these powers are not expressly there, but these powers have not been expressly removed as well, my lord. So, my lord, in my respectful submission, my lord, the appellate court's power is to be traced under CPC, which says that the in exercise of appellate jurisdiction, the appellate court can set aside the award, can vary the award, can confirm the award, or with the agreement of parties, my lord, is different kind of order can be passed. Now, my lord, so long as all these powers are subject to the express limitation on the power of setting aside, which is that the court in exercise of section 34 cannot review the merits of the matter, or there shall not be any reappreciation of evidence. Now, that's the test in my respectful submission. That is the test to be applied on all these 4 powers. The power to set aside, the power to refuse to set aside, the power to vary or modify, or the power to pass an order in terms of the agreement between the parties, my lord.
It's an appellate power.
It's an appellate power, my lord, which has not been taken away by this statute, my lord. The Arbitration Conciliation Act does not take any of the powers, my lord. My submission is that the express words relate only to setting aside. Right, my lord? But, my lord, the power to set aside is not to be seen as the power. Power to set aside is a power within the larger ambit of section 34. So 34 is the larger power in which, my lord, there is the power to set aside, there is the power to modify, there is the power to refuse to set aside, and there is also the power that if the parties are in agreement, then a different sort of an order can be passed, my lord. And the limitations only being this, that in exercise of any of these standalone powers, the court does not have to interfere with the merits of the matter or reappreciate the matter. But in that light, my lord, I have, my lord, taken liberty to just request your lordship to view the third referral question. My lord, the third referral question as framed is that whether the larger power to set aside entails the power to modify. Lord, in my respectful submission, my lord, if the words, my lord, if your lordship would have the second page, whether the power, and remove the words to set aside, and it may be read like this, whether the power under section 34 of the act, being the larger power. So 34 is a larger ambit, will include the power to set aside and the power to modify. So section 34, in my respectful submission, is to be read as a large power. Setting aside is a part of that power as much as the other 3 powers which I mentioned, the power to modify, the power to refuse to set aside, and the power with the agreement of parties. This is my respectful submission. Great.
Lord, sir, I need half an hour for the rejoinder.
Not just now,
Huh?
not just now, not at this time.
No, not at this time. No, but I'm saying that if they could never assist your lordships, my lord, my learned friends. If
Ask to
they-
let them complete and then you can.
That's what I'm saying, my lord, that it would be fair, my lord, that they assist your lordships and
Yes,
give me 20 minutes to half an hour at the end, my lord, when my friends conclude.
Yes, please.
Yes, I'll take a short while and then Mr. Banerjee will do most of the argument. We've prepared a common compilation between the three of us so that there isn't a repetition, and that's been filed, Millers. There's one note that we prepared. What he says. This is coming shortly at the note is coming.
Ancestral compilation, the common compilation.
Yes, Millers.
Now there are
There
three
are
views.
six volumes.
There are three.
There's six volumes.
There are three views which are coming. Or we can divide broadly into three views. One is that the power to set aside subsumes in it power to modify, in which cases will you modify? When will the court exercise the power of modification? Will be relatable to curable defects, not something which are uncurable by the court. But this has to be done. One aspect, one side says this should be done without going into the merit or reappreciation of evidence. There may be some difficulty in that, because whenever we are going to the patent illegality public policy clause, there is element of reappreciation. But not as an appellate court, but as a court within the confines of that power. See that. The second issue which has been argued